Okay, let's unpack this. Have you ever wondered what it really takes to become a financial professional? In the securities industry,
Mm.
beyond just getting a license. What are the hoops, the hidden rules, the deep background checks involved?
Yeah, there's quite a bit under the surface.
Today, we're doing a deep dive into exactly that. We've got some detailed source material here on broker-dealer employee registration, regulations, all that stuff.
Dense stuff, usually.
Right. So our mission really is to pull out the most important nuggets for you, the key insights from all this material so you feel well informed without getting totally bogged down in jargon.
And what's fascinating, I think, is how these rules aren't just about ticking boxes for compliance. They're fundamentally designed to protect you, the investor,
Ah, okay.
and maintain integrity in the markets. It's a very intentional, layered system.
A layered system, I like that. It sounds like a truly robust framework then, always kind of keeping the investor in mind. So where do we start? How do we begin peeling back these layers?
Well, first, let's nail down who we're even talking about. These regulations often mention associated persons of a FINRA member firm.
Okay, associated persons. Who falls into that category?
So that's your officers, directors, partners, or branch managers of the firm. Pretty straightforward there.
Right, management types.
Yeah, but it also covers basically any employee of the member firm. There's a key exception, though,
Oh.
unless their role is solely clerical or ministerial, purely administrative.
Gotcha. So if you're just handling paperwork, maybe not.
Exactly. And it also includes people engaged in investment banking or the securities business that's controlled by the member firm.
Hmm.
The crucial insight here, I think, is that this distinction creates a kind of legal firewall. It makes sure only people who've gone through all the checks, the registration, the oversight, only they can legally guide your investments.
So it's not just a job title.
No, not at all. It's about the legal privilege, really, to handle the public's money.
That makes perfect sense. Okay, so if you're not one of those associated persons, or maybe you're in that purely clerical role, what can you do? And maybe more importantly for our listeners, what can't you do? What's that line?
Right, the line is important. Non-registered individuals, their contact with customers is very limited. Understanding these limits is key for you, the listener.
Okay,
They can, for instance, invite people to firm-sponsored events, like a seminar or something.
makes sense.
They can ask a prospective customer if they want to talk investments with a registered rep.
Just making the connection.
Exactly. Or ask if someone wants to get investment literature from the firm, brochures, that kind of thing.
Okay, so basic logistics and invitations. What's strictly off limits?
Okay, this is critical. They are strictly prohibited from discussing investment products. General or specific, doesn't matter.
No product talk.
None. They also can't pre-qualify potential clients. Asking about their financial status, their history, their goals.
Ah, so no digging into finances.
Definitely not. And they can't solicit new accounts or orders. That's a huge one.
That seems like a really important safeguard. Ensures you're only talking specifics with someone actually qualified.
Precisely. And here's another detail. Registered people can't pay commissions or like finder's fees to non-registered folks for referrals.
Oh, interesting. So if my accountant refers me.
Your rep can't pay the accountant a fee for sending you over. Now, they can certainly recommend the accountant services, that's fine, but no kickbacks for the referral itself.
Something that maybe sounds simple but probably isn't, is just accepting a customer order, like taking down the details. How complex is that?
Oh, it's far from simple in the eyes of the regulators. Accepting customer orders is explicitly not clerical.
Right. So it's not just jotting something down.
Not at all. Anyone associated with a member firm who accepts customer orders must be registered, period, in an appropriate category.
What if the registered person isn't available? Like they stepped away?
Okay, good question. In that scenario, an unregistered associated person might occasionally be allowed to transcribe the order details, just write them down as the customer provides them.
Okay, transcript, but
But, and this is key, the registered person must contact that customer later to confirm all those details before the order is actually entered.
so verification is mandatory.
Absolutely mandatory. It really highlights the emphasis on accountability and precision, making sure every detail is confirmed by someone qualified before money moves.
So it's clear there are different roles and definitely different levels of what people can do, which leads to registration, right?
Exactly. The scope is huge, so it makes sense that different jobs need different qualifications. And registration with FINRA, let's maybe break down the two main tiers.
Okay.
So most associated persons, as we define them, have to register with FINRA. It depends on the firm's business, the products they handle, the person's role.
Makes sense.
FINRA basically recognizes two main levels. You've got your registered representatives, usually called reps,
Right, the sales folks.
typically, yeah, involved in direct securities activities with customers. And then you have principals.
Then they are.
Principals are generally your officers or other management supervisory staff, the people responsible for running the firm's securities business, overseeing things.
And getting to either level involves exams. Serious exams, I imagine.
Oh, yeah. Sometimes multiple exams.
The sheer number and how specific they get, it really shows how specialized this world is, doesn't it? Is the idea that nobody can really be an expert in everything?
That's exactly it. You hit the nail on the head. It's about ensuring deep, sometimes narrow expertise. So new folks usually start with the SE exam.
Yes.
Securities Industry Essentials. It's kind of a general knowledge prerequisite. You pass that first.
Okay. Step 1?
Then you move on to the specific FINRA qualification exams for your role. And yeah, they reflect that specialized expertise.
Give us some examples, like for the reps.
Sure. For registered reps, probably the best known is the Series 7. That's the General Securities Representative exam.
The big one.
Kind of the comprehensive one, yeah.
Yeah.
It covers basically all common securities products: stocks, bonds, mutual funds, options, direct participation programs, variable contracts, the works, primary, secondary markets.
Wow, okay. Broad.
Very. But then there are more limited ones, like the Series 6. That's for investment companies and variable contracts products.
So more focused.
Much more focused. Think mutual funds, closed-end funds, but only the initial offering. Unit investment trusts, variable annuities, variable life insurance, and 5 and 29 plans.
Yeah.
Municipal fund securities.
Okay. And others.
Oh, yeah. You've got like the Series 79 for investment banking reps, people advising on mergers, acquisitions, debt, and equity offerings.
M&A stuff.
Right. Or the Series 99 for operations professionals. That's more back office, client onboarding, handling securities, reconciliation, regulatory reporting, IT security. Different world.
It really shows the different career paths within a firm.
Absolutely. When I studied for my Series 7, it felt like trying to memorize the phone book. Seriously. But knowing every single number or rule in this case is critical. Getting it wrong could cost someone dearly.
I can imagine. Now, what about the principals? The supervisors?
Right. Their exams definitely shift focus toward supervision. The Series 24, for example, is the General Securities Principal exam.
What does that let you supervise?
Pretty much all areas of the firm's investment banking and securities business. Underwriting, trading, market making, advertising, overall compliance. It's broad.
But any exceptions?
Yes. Importantly, it does not cover supervising municipal securities or options activities. Those require different principal licenses.
Ah, okay. Any other examples?
Sure. There's the Series 9 and 10. That's the General Security Sales Supervisor license. It's more limited.
Limited how?
Limited to supervising the sales activities for things like corporate securities, mutual funds, variable contracts, munis, options, government securities, but not things like underwriting, trading, or the firm's overall financial compliance.
So different levels of supervision require different exams too. Very layered.
Extremely layered.
Okay, these exams sound tough. What happens if you don't pass the first time or the second? Is there a limit?
They are challenging. And yes, there are rules about retakes. If you fail a qualification exam, there's a 30-day waiting period before you can try again.
30 days between attempt 1 and 2.
Correct. And another 30 days between attempt 2 and attempt 3.
Okay. But what if you fail that third time?
Well, then the waiting period is much longer. You have to wait a full 180 days, that's 6 months, before you can try again, or any time after that.
Wow, 180 days, that's significant.
It is. And related to exams, here's something really critical. A potential aha moment, maybe. Exam confidentiality.
Sounds serious.
It is extremely serious. If INRI has very strict rules. You absolutely cannot remove any part of the exam from the testing center.
Makes sense.
You can't reproduce it, disclose it to anyone, receive exam questions or answers from someone else.
Yeah.
Basically, anything that compromises the exam content is forbidden.
And the consequences? Severe. Violating these confidentiality rules can lead to serious sanctions. We're talking suspension or even permanent revocation of your registration. They do not mess around with the integrity of the exams.
Right, because that undermines the whole qualification process.
Exactly.
Okay, so passing those exams is a huge step. A monumental achievement, probably feels like it.
Yeah.
But it's really just the ticket to get on the field, isn't it?
That's a great way to put it.
Because once someone is registered, the focus shifts, right?
Okay.
From proving knowledge to ensuring constant ethical conduct. And that's where the firm's responsibilities really kick in.
The firm itself has major obligations. Each member firm has to establish, maintain, and importantly enforce robust written procedures for supervising their reps and associated persons.
Written procedures, got it.
And they need to keep records of those procedures. They also have to meticulously review and endorse in writing all the transactions done by their reps.
All transactions.
All transactions and related correspondence, emails, letters, etc.
Plus, they have to approve customer accounts when they're opened and then review them periodically, looking for potential misconduct, churning, unsuitable recommendations, things like that.
Proactive checking.
Yes. And they also have to inspect certain locations. Key locations like an Office of Supervisory Jurisdiction or OSJ.
OSJ.
Think of it like a main branch office, a hub where key supervisory activities happen, like approving accounts, reviewing correspondence, maintaining records. They have to inspect those at least once a year.
Annual inspection.
And critically, firms have to verify the good character, the business reputation, qualifications, experience, all that. For everyone they certify for registration.
Before they register them.
Yes, and then continuously monitor their good standing afterwards. It's not a one-time check.
Constant vigilance.
Exactly. And to make that supervision concrete, each registered rep must be assigned to a specific supervisor, a principal who has passed the right exams for that supervisory role.
So there's always someone directly responsible.
Always. If regulators find a violation, one of their very first questions is always, who is responsible for supervising that person? Accountability is deeply baked into the system. It creates that clear chain of responsibility, all aimed at protecting you, the investor.
Okay, so the exams are done, the knowledge is verified, the supervisor is assigned, but before anyone can actually start working, there's still some paperwork, right? Like the official registration itself.
Absolutely. That's where Form U4 comes in.
Yeah.
That's kind of the bedrock administrative piece.
Form U4, tell us about that.
Right. The registration process usually kicks off by submitting Form U4. That stands for Uniform Application for Securities Industry Registration or Transfer.
Uniform application, okay.
This form, usually along with a fingerprint card, gets filed with FINRA's Central Registration Depository, usually called the CRD.
CRD, what's that?
Think of it as a huge automated database. It holds the permanent record for every registered person in the securities industry.
Permanent record, like what?
Their entire employment history in the industry, any disciplinary actions taken against them. Everything. It's a vital tool. State regulators use it. Other SROs use it. The SEC uses it.
So it's the central hub for background info. What does the U4 itself ask for?
A lot. Extensive personal background info, residential history for, I think, 5 years, business history for 10. And crucially, you have to disclose any violations of laws or SRO rules.
Any violations, like what?
Has the SEC ever issued an order against you related to investments? Any criminal history, especially felonies or certain misdemeanors, regulatory actions, customer complaints. It's very comprehensive.
Disclosure is key, which leads to something that sounds, well, pretty bad. Statutory disqualification. That sounds like a career ender.
It can be, or at least a major hurdle. Statutory disqualification, or SD, generally a broker-dealer cannot employ someone subject to SD in any registered capacity.
Cannot employ them, full stop.
Well, not quite full stop. They can't employ them unless NRI gives specific permission. It requires a special proceeding.
Okay, so there's a potential path back. What causes someone to become statutorily disqualified in the first place?
Several things. Common causes are serious past regulatory issues, like being expelled or suspended from an SRO like FINR, or having your registration denied, suspended, or revoked by the SEC or other agencies like the CFTC, even foreign regulators sometimes.
So, regulatory sanctions.
Right. Also violating securities or commodities laws or MSRB rules, or even just helping someone else violate them.
Aiding and abetting.
Yep, and failing to supervise someone under you who commits a violation, that can get a supervisor disqualified too.
Unless
Unless they can show they had a reasonable supervisory system in place and they actually carried out their duties properly under that system.
Okay, that's an important defense for supervisors. What about criminal issues?
That's a big one. Being convicted within the last 10 years of any felony or certain misdemeanors, basically anything related to investments, fraud, theft, extortion, bribery, perjury, dishonest or unethical conduct.
10 years is a long look-back period.
It is. And here's a really critical point for anyone filling out that Form U4. If you intentionally submit false information or you omit relevant facts, like not disclosing a conviction, that itself will cause immediate statutory disqualification.
Honesty is paramount on the U4.
Absolutely. And even if someone gets a pardon for a felony, they still have to disclose the original conviction on the U4.
Really? A pardon doesn't wipe it clean for disclosure.
Nope. The pardon might remove the punishment, restore civil rights, whatever,
Yeah.
but it doesn't erase the fact of the conviction. It still happened, and it must be disclosed. Failure to do so is a huge violation.
Wow. Okay, so let's say someone is subject to SD. How does a firm try to hire them? You mentioned a special proceeding.
Right. It's called an eligibility proceeding.
Hmm.
The firm has to apply to FINRA for permission.
And FINRA just decides. What do they look at?
They look at a lot of factors. The nature and severity of the event that caused the disqualification, how long ago it happened, any misconduct since then, any mitigating or aggravating circumstances, what specific job the person would be doing, and, importantly, the disciplinary history of the firm itself and the person who would be supervising the SD individual.
They look at the supervisor's record, too.
Yes. And if FINRA does grant permission, it almost always comes with strings attached. Specifically, heightened supervision,
Heightened supervision, meaning what?
meaning a very specific, tailored supervisory plan for that individual must be put in place and followed rigorously.
Like what kind of things?
Could be things like having the supervisor review and approve every single order ticket before entry, reviewing and approving all incoming and outgoing correspondence, all new account forms, documenting every single review, holding frequent meetings, addressing any customer complaints immediately.
Oh, much closer monitoring.
Much closer. It really shows the system's focus on, continued vigilance and managing risk, even when allowing someone with a past issue back into a registered role.
It makes sense. Before you trust someone with your life savings, essentially, you want to know they've been thoroughly vetted, right?
Absolutely.
And the firms feel the same way. This vetting goes even deeper than just that U4 form, doesn't it?
It does. Under FINRA's rules, firms have a responsibility to conduct a thorough background check. They have to rigorously investigate an applicant's character, their business reputation, qualifications, experience.
So due diligence on the applicant.
Right. And they also have to perform a search of reasonably available public records. Why? To verify that the information the applicant put on their Form U4 is complete and accurate.
Checking their work, basically.
Essentially, yes.
Yeah.
And if someone is switching firms, coming from another broker-dealer,
Yeah.
the new hiring firm is required to make a reasonable effort to get and review the person's most recent Form U5.
U5, what's that?
The U5 is the Uniform Termination Notice for Securities Industry Registration. When someone leaves a firm, the firm files a U5. It details the reason for termination.
Ah, so it might say if they were fired or left voluntarily.
Exactly. And crucially, it requires disclosure of any allegations of misconduct or investigations pending when they left, so the new firm can see if there were any red flags at the old job. It's about ensuring transparency throughout their career history.
That U5 sounds really important for hiring decisions.
It is. It helps prevent problematic individuals from just jumping from firm to firm without scrutiny.
Okay, what about fingerprinting? I feel like I've heard about that in finance.
You have. On top of everything else, there's a fingerprinting requirement. Most partners, officers, directors, and employees of a broker-dealer have to be fingerprinted.
Why?
For a criminal background check, the prints are submitted to the U.S. Attorney General, FBI check, essentially.
Okay, does everyone have to do it?
Most people involved with the firm do, but there are some specific exceptions.
Like who?
Well, the requirement generally doesn't apply to associated persons who don't sell securities,
Okay.
who don't have access to securities or money or the firm's original books and records,
Right.
and who don't supervise people who do those things.
So if you're really removed from the money and security side.
Pretty much. The sort of simplifying principle is, if a person comes into contact with customer funds or securities or the firm's core books and records, fingerprinting almost certainly applies.
Any other exceptions?
There's one for firms that only deal in specific types of securities that aren't usually evidenced by physical certificates, like certain mutual funds or variable annuities sold directly. But for most typical broker-dealers, fingerprinting is standard procedure for most staff.
Got it. So we've covered the deep dive into someone's past at the federal level with FINRA and the SEC. But the scrutiny doesn't stop there, does it?
Not at all.
There's also the state level. Individual states have their own rules, often called blue sky rules. What's that about?
Yeah, blue sky rules. It's a great name, isn't it?
It is. Where does it come from?
It refers to state-level securities laws. The term supposedly came about early in the 20th century, basically meaning State regulators were there to protect investors from fraudulent schemes promoted by people selling nothing more than a piece of the blue sky, worthless investments.
Selling you air, basically. Okay, so how do these blue sky rules work today?
Well, on top of the FINRA registration we've been talking about, registered representatives generally also have to register as agents in each individual state where they plan to conduct business.
Each state. So if I have clients in 3 states,
You likely need to be registered as an agent in all 3 states, plus your home state, probably.
wow. Does that involve more exams?
Often, yes. Most states require passing additional exams like the Series 63, or maybe the Series 65 or 66.
What do those cover?
They specifically cover state securities regulations, often based on a model law called the Uniform Securities Act, which tries to harmonize rules across states, but each state still has its own nuances.
And the firm has to register too.
Yes, the firm itself usually needs to register in the state and pay fees to the state's securities administrator. That's a title for the state regulator.
Okay, so reps and firms register state by state. Anything else under blue sky?
A really crucial point is about the securities themselves. Any security sold to a client must either be registered in that client state, sometimes called being blue-skied, or it has to qualify for an exemption from registration in that state.
The security itself needs state approval.
Or an exemption, yes. This gets particularly important when you have cross-border stuff, like the rep is in New York, the client is in California. The security needs to be properly registered or exempt in California for that sale to be legal.
Lots of potential pitfalls there if you're not careful.
Definitely requires careful compliance tracking by the firm.
Okay, it's clear the bar is set incredibly high just to get into this profession. The exams, the background checks, the multi-level registrations.
It's a rigorous process.
But the learning and compliance doesn't stop once you're in, right? I
No.
mean, the industry changes, rules change.
Absolutely not. The learning never truly stops. The industry demands constant evolution, and that's formalized through continuing education requirements, or CE.
Continuing education, tell us about that.
Right, so registered folks have to participate in an industry-mandated CE program. It has two main parts.
2 parts.
First is the regulatory element. This part is created and administered by the regulators, like FINRA.
Okay, the official stuff. How often?
Registered reps have to complete this starting on their 2-year anniversary of getting registered initially.
2 years in?
Yep. And then every 3 years after that for as long as they stay registered. Oh, and if they have certain disciplinary actions, that can reset the clock too.
So ongoing, what's the content like?
It focuses on compliance, regulations, ethics, sales practices, current standards. It's often delivered through interactive, computer-based scenarios, trying to make it practical.
How does it work logistically?
FINRA notifies the firm about 30 days before someone's CE window opens. Then the rep have 120 days to complete the module.
Plenty of time. What if they don't?
Big consequences. If they fail to complete the regulatory element within that 120-day window, their registration becomes inactive. CE, inactive,
Inactive means?
means they're prohibited from doing anything that requires registration. Can't function as a rep, can't get paid commissions for work requiring registration. They have to get current to reactivate.
Serious motivation to get it done.
Very. And they made it more convenient now. It's delivered online through FINRA's CE Online program.
Okay, that's the regulatory element. What's the second part?
The second part is the firm element. And this is the responsibility of each individual broker-dealer firm.
The firm's own training? Who does that apply to?
It applies to any registered individual who has direct contact with customers in sales, trading, or investment banking, and also their immediate supervisor. These are called covered persons.
So customer-facing roles and their managers.
Exactly. And the firm's responsibility is annually they have to conduct a needs analysis, figure out what training their covered personnel need based on recent regulatory changes, new products, sales practice issues they've seen, etc.
Analyze the needs.
Then, based on that analysis, they have to develop a written training plan for the year.
A formal plan. Do they submit it to FINRA?
Not usually.
Yeah,
They have to
okay.
keep records documenting the plan's content and who completed the training. But they typically only provide it to regulators if specifically asked, like during an examination.
Okay. What kind of training is expected?
Well, there are minimum standards. The training should aim to improve securities knowledge, skills, professionalism. It should cover relevant products, services, strategies, with a real emphasis on investment features and risks, suitability rules, sales practices, and any applicable regulatory requirements. It needs to be relevant to the firm's actual business.
So it keeps everyone up to date on rules and risks specific to their job.
That's the goal. Keep them sharp and compliant.
That makes perfect sense. Now, here's a specific situation. What happens if a registered person gets called up for active military duty? Do they risk losing their registration while they're serving, or have to retest when they come back? That seems like a potential hardship.
Yeah, that's a really important consideration, and there are specific protections in place. It falls under the inactive status military duty provision.
Okay. How does that work?
If a registered person is called into active military service, they, or their firm, just need to notify FINRA properly. They're then placed on a special inactive status.
Special inactive status. What does that mean practically?
During their active service, they are not permitted to function as a registered rep.
Hmm.
They can't contact customers in that capacity.
Okay. Can't work as a rep while deployed.
Right. However, they may be able to continue receiving compensation that's based on securities transactions from their existing clients before they left, like ongoing trails or commissions from accounts handled by someone else while they're gone, if the firm's policy allows.
Ah, so they might still get some income. What about the rules?
They get relief. They're exempt from that 2-year limit on inactive status that usually applies if someone leaves the industry.
Okay, so their registration doesn't just expire after 2 years out.
Correct. And they are also exempt from continuing education requirements while on active duty.
No CE while serving. That's helpful. What about when they return?
When they're discharged, they receive registration relief. They basically get a period of time to get back into the swing of things without having to re-qualify immediately. And this applies whether they return to their old firm or join a new one.
That's fantastic. It really is a key protection for service members. Ensures their professional standing is preserved while they're serving the country.
Exactly. It's a well-thought-out provision.
Wow. We have really gone on quite a journey, haven't we? Through this whole intricate world of financial professional regulation.
They covered a lot of ground.
Yeah, hopefully giving you, the listener, a real shortcut to being truly well-informed, from just defining who's who to the exams, the background checks, the state rules, that ongoing CE, even the military provisions. It's quite a system.
It really is.
Yeah.
And if we kind of connect all these dots, pulled back to the bigger picture, it becomes pretty clear that these detailed regulations, this continuous oversight, they aren't just bureaucratic hurdles.
Right, not just red tape.
No, they are really the scaffolding, the framework that supports the trust and the integrity that's absolutely crucial to the entire financial system.
Yeah.
Understanding all this, I hope, helps you appreciate the really rigorous standards placed on the people who handle your investments.
And the constant effort to maintain market confidence.
Exactly.
So, thinking about all this, what does it all mean for your relationship with a financial professional? You know, knowing this depth of regulation, the checks, the ongoing education, what new questions might you consider asking just to ensure you're working with someone who truly meets these high standards?
Good question.
Something to maybe mull over until our next deep dive.